they said these shouldn't be regulated. This is an information service. Now, you sort of can't play ducks and drakes with this. Having these policies sort of shift in depending on what issue pops up in the moment. They chose a deliberate course of action consistent with the idea that this was an internet information service. And now they want to drag back part of that, but they don't want to impose a common carrier regulation. They don't want to impose Title II obligations just for the purpose of net neutrality. Now, some of the advocates, Free Press, for example, and others, are arguing for Title II. They want these things to be really dumb pipes. That's it. But the FCC, I think, does not see it that way. They don't want to constantly maneuver through these Title II, Title III, Title I, and sort of have something that's just right. What I object to is, as a matter of statutory interpretation, that just isn't correct. That just doesn't make sense to me as a matter of simple statutory interpretation. That the FCC, there have to be boundaries in the way in which you can shape and reshape your jurisdiction depending upon what particular problem arises. So my answer would be, could they go back on Brand X? Yeah, it might be a little dicey to go back to the Supreme Court and explain why, whoops, we didn't really mean it back then, folks. I mean, there is an Administrative Procedure Act that says they have to have a rational basis. And that means having consistent rational bases for the decisions they make. They can't just have back and forth. They can change their mind, but they have to have a pretty good reason for it. I think if they would try to go back on Brand X now, at least the Court of Appeals would probably beat it to a pulp.
So there's no authority. FCC doesn't have it. DOJ, I don't think. Who would be able to?
Well, I wouldn't say the DOJ does. Why do you say the DOJ would?
Well, I mean,
that isn't what Trinko says. The Trinko case involved a case where the FCC had precisely addressed the problem that was addressed by the court. The perfect overlap. The FCC and the Supreme Court said, look, it seems to us the FCC's already taken care of this problem. We don't need the antitrust laws to duplicate the remedy or to pile on. That wouldn't be the case if the FCC has already said, look, we're not in this business of regulating information services. I think the Justice Department would be perfectly within its jurisdiction.
I just wanted to follow up on one point, and this is an issue I've been trying to figure out myself. Is the act of regulatory classification a matter of straight up law, statutory interpretation, or is it a policy decision, or is it a mixture of law, fact, and policy? And how would that play to the idea of reclassifying something later?
That's a great question. I don't know the answer to that. I guess my instinct is to say that it's probably a regulatory rather than a statutory question. It probably lies within the agency's jurisdiction to make reclassifications of what this service is or that service is. But again, they're not totally free to make those reclassifications, as you know. They have to come up with a rational basis, which means basically discrediting everything they said just a few years ago. They have to go back on the Brand X case. They'd have to go reverse themselves on the broadband wireline case. So it isn't just that they deregulated cable modem service, they also deregulated DSL service. And all the reasons that they gave for doing that, now they would come back to haunt them. But I don't think I don't know that there's you can say that the statute forbids that. I didn't understand Brand X to say that.
Neither did I. I just have one other question which relates to the previous one. If you look at this as a matter of statutory interpretation or regulatory classification, you might conclude, well, if they had a factual basis for it, they could say, I made a mistake, or things have changed, or something has happened. But if you look at it a little bit differently, and looked at it from the perspective of, would the agency be declaring the service now to be a common carrier service? And can they do that under the statute if the provider isn't holding itself out as providing a common carrier service?
It's a little bit, it's sort of like a question that was raised way back in the 60s in cable television, whether or not cable could be classified. They weren't holding themselves out as common carrier either. But it's not quite clear what, to me, I've never quite understood the holding out point. I don't know what it means. Henry, I don't really. What it means to say you hold themselves out. You operate a certain business, and then the regulator stands back and looks at it and says, well, it looks to us like you really are operating more or less as a common carrier. And to the extent you are, it doesn't matter what you call yourself. You can call yourself a duck, but we call you a common carrier. And I think there's probably some of that to there. I don't know what features of the broadband service would not conceivably be said to be, could not conceivably be said to be open to all, because they do in fact throw this service out to all. It's not tailored to all. So in that sense, maybe it could be covered.
That part of the test, I think there is no question they generally hold themselves out to provide service to the public for a fee.
Yeah.
But the other piece of the traditional common law test for common carriage is that they offer to transport information of the user's choosing, and they do not mess with that. And that's where I think this service is different, and that was the basis of the cable modem ruling and the basis of Brand X.
Yeah. Interestingly, this issue comes up now in the context of the current rulemaking, because what the FCC is proposing to do is not to treat them as common carriers. Indeed, it allows the broadband providers to manage the network and to provide managed services. Nobody in God's name knows what a managed service is. The FCC doesn't know what managed service is, but they're throwing this out. The idea being that there can be some services in which you can be discriminatory. But they don't have it doesn't fit any known category of service. So maybe this issue will get played out again. But basically the idea of what they're trying to do is approach common carrier type regulation, at least for this narrow service. Interestingly enough, they're going beyond it, however, in a curious sort of way. The common carrier regulation of AT&T, for example, I'll take one example, does not prohibit AT&T from offering charging different amounts to different users according to things like quality of service, amount of bandwidth, etc. What the FCC is doing actually is proposing that broadband providers would be prohibited from charging different content providers or application providers according to things like quality of service guarantees, etc. So it's such an odd mixture of common carrier and non-common carrier regulation that really hard to fit with any of the traditional type 2 type things.
Well, we have a reception right outside of the atrium, and we have lots of tasty items and refreshments. And if people have questions, I hope that maybe they can talk you out of the and let's give Glen Robinson.
All right.